Sure.
All right, we're recording.
Great. So I'm Mary Clark. I am the PCAN coordinator at Highest Pennsylvania. PCAN stands for the Philadelphia Citizenship Action Network, and I help coordinate citizenship application assistance and classes around the city with a number of partners that we work with. Do you want to introduce yourself, Mary Pat?
Sure, yeah. Hi, everyone. This is Mary Pat Pileggi. I'm an attorney in the welfare unit at Community Legal Services, and I specialize in immigrant eligibility for and access to public benefits. So I will be speaking with you today about a couple of things related to public charge, but most specifically on the issues related to public benefit access and how public charge might change that for some folks.
Great. So we're all here because last month there was a change made to the public charge rule. So the public charge or a public charge test has existed in immigration law since the 1880s, and it's been used as a way to exclude particular immigrants from entering the country or remaining in the country based on their perceived inability to support themselves financially. Under our current law, so before the rule, so last month, the rule was changed. The change is not going to take place until October. So under the current law as it stands, immigration officials can deny some immigrants a visa or a green card if that official finds the immigrant is likely to become a public charge. So today we're going to talk about both the old rule as well as the changes coming to the rule so that folks can get a better understanding because I think there's been a lot of confusion. It's confusing to begin with, but then I think the media's presentation of the changes to the rule have been confusing as well. And I know we've been getting a lot of calls from folks who don't understand the changes to the rule and think it applies to them when it doesn't. So we're here today to talk about all of those changes. So under the current rule, immigrants can be denied admission based on these public charge grounds if they're applying for green cards, visas, or visa renewals. It's important to note who is not subject to the public charge test because, like I said, there's a lot of confusion and a large portion of the clients that we work with are not subject to the public charge rule. So individuals who are applying for U.S. citizenship are not subject to the public charge test. Sorry, yeah, I'm still on slide 3. Folks that have a green card and are applying to renew their green card are not subject to the test. Similarly, if someone's applying for asylum, if they're applying for DACA renewal, if they're applying for TPS, temporary protected status, or a TPS renewal, the public charge test does not apply at that point. Immigrant victims of domestic violence who are submitting VAWA petitions are not subject to the rule. U visa applicants who have been victims of crime, T visa applicants who are trafficking victims, special immigrant juveniles, all of the individuals on your screen at the point of applying for these benefits are not subject to the public charge rule. The list is longer than this, and I would say if you have any questions about that, I would be happy to provide you with the full list of what applications are not subject to the public charge test. But like I said, green card applications, initial green card applications, visa applications, and visa renewals would be where the public charge test would come into play. Next slide. So in addition to the fact that not all applications are subject to the public charge test, there are certain individuals who are exempted from the public charge grounds of inadmissibility when they apply for their green cards. So under statute, meaning Congress has passed a statute and has passed a law saying that these individuals are exempted, that would be refugees, asylees, VAWA petitioners, special immigrant juveniles, U visa holders, T visa holders. When these individuals apply for green cards, they are not subject to the public charge test. However, if these individuals apply for a green card not based on their status as a refugee or an asylee or the categories listed here, but rather based on a family petition, the public charge test would apply. So what that means is, for example, if someone got status as an asylee, married a U.S. citizen, and then applied for a green card based on their marriage to a U.S. citizen, rather than based on their asylee status, the public charge test would apply. That's going to be a small number of folks, but it's important for folks to understand that when we talk about the exemption, we're talking about these individuals when they get their green card based on this status. So if someone is a refugee, gets their green card based on being a refugee, the public charge test does not apply. This is important because, as Mary Pat will talk a little bit later, a lot of individuals may not understand that they are exempted and may get off of public benefits when they don't need to. Another thing I want to point out is that green card holders, like I said, when individuals are applying for green card renewals, the test does not apply. That said, if someone has a green card and travels more than 6 months or more outside of the country, when they return, they may have to go through the public charge test. So who is at risk? We're going to talk about this in a little more detail, and hopefully it'll be a little more clear as we go through. So like I said, the main group of people who are at risk of the public charge grounds of inadmissibility are individuals who are applying for visas or green cards based on family petitions, okay? So not based on those other grounds that we talked about. Like I just explained, folks who have green cards who leave the U.S. for 6 months or more could be at risk of public charge when they seek to re-enter. But for green card holders who aren't traveling more than 180 days outside of the country, there is no risk. There's no risk when they renew their card. There's no risk when they apply for citizenship. There's no risk in simply maintaining their green card. So who makes the decision about public charge inadmissibility? When we're talking about green cards, green card renewals, when we're talking about green cards, we're talking about visa applications. It's either the Department of State or USCIS, which is the U.S. Citizenship and Immigration Services. The Department of State makes public charge determinations for people who are applying for visas outside of the country in order to enter the U.S. And then within the U.S., the Department of Homeland Security, the agency of USCIS, makes the public charge decisions for people who are applying within the U.S. So if someone wants to renew their visa when they're already here, or if someone is applying for a green card, they're in the U.S., they're eligible to adjust their status within the United States, they would apply within the U.S. with the Department of Homeland Security. So the current changes that were announced on August 14th are specifically for USCIS in the United States. We fully expect that similar rule changes will be made at the Department of State and consular level, but as of right now, the rule we're talking about today is changes to USCIS public charge policy. So under the current policy as it exists, before the changes are implemented, a public charge is someone who depends almost exclusively on the government for financial support. And an immigrant's current or past receipt of certain public benefits can be considered when making that public charge determination, but those benefits are TANF, general assistance, SSI, or long-term medical care assistance, things like long-term nursing care or institutionalized medical care. No other benefits can be considered under the current policy, meaning things like food stamps and medical assistance are not considered under the current rule as it stands before the changes are made. And before we move on to the next slide, I wanted to make a note. So this is the current policy. In practice, and from an immigration law standpoint, Under the current rule, immigrants have generally been able to overcome the public charge test by submitting what's called an affidavit of support. So an affidavit of support is a contract that individuals sign with the government, and by signing that contract, they agree to use their financial resources to support an intending immigrant. Up until now, where there was a qualifying affidavit of support, meaning someone had signed off to say that they would financially support the immigrant and they had sufficient income to support the immigrant, up until now, the intending immigrant generally would not be found inadmissible under public charge grounds if a qualifying affidavit of support existed. So that's one of the major things that's going to be changing from the current to the new rule. Sorry, I'm still going. Sorry. Okay, I was thinking this is the end of my section. So on August 14th, USCIS published new rules that redefined how they're going to define the word public charge, or the term public charge. Like I mentioned before, the Department of State is starting to make changes to the way they adjudicate cases, but the complete changes made that we're talking about today are specifically for USCIS. So USCIS's new rule is scheduled to take effect on October 15th. That said, there are several lawsuits that have been filed that may delay or even cancel the new rules going into effect. So we would encourage folks to stay abreast of what's going on to understand whether or not the new changes actually do take effect on the 15th or not. So the new rules, like we mentioned before, they do not change and they can't change who is subject to and who is exempt from the public charge grounds of inadmissibility. So individuals who are exempt from the public charge rule that we already discussed will continue to be exempt from the new rule. So therefore, refugees, asylees, VAWA recipients, everyone in those categories that I mentioned before will remain exempt under the new public charge rule. And similarly, green card holders who don't travel extensively will also not be subject to the new public charge rule.
Before Mary Pat starts, there's two questions, I think, for Mary. So I'm just going to read them and then you can respond. The one is, my understanding is that it doesn't apply to I-751, removal of conditions on permanent resident applications. And then, is that correct?
That's my understanding.
Okay. And then the second question is, if someone has DACA, gets married to a U.S. citizen, and adjusts their status, are they subject to the public charge rule? And then if they go on to apply for their undocumented parents, will the parents be subject to the public charge?
Yeah, so yes, in both cases. So like I was saying before, what I wanted to say was when folks apply for DACA, there's no public charge test when you apply for DACA. Family petitions across the board, public charge does apply. So if you have DACA and then you marry a U.S. citizen and you apply for your green card based on that, yes, the public charge will apply. And then if you petition for your family members in the future, the public charge test will apply as well.
Great. And then tomorrow, the question you asked, I think it's actually going to be covered later in the presentation. So we'll come back to that if we didn't answer your question. All right.
Great. So hi, this is Mary Pat. I'm going to take over for a little bit. So we have this public charge policy that's been in place for a long time that Mary just reviewed, that defines public charge as it relates to people's eligibility for and past receipt of cash assistance and long-term care medical assistance. And those two programs are, there are very few people that are in the world that are eligible for those two programs, cash assistance and long-term care medical assistance. And as a result, that current public charge definition that we have applies to a very small group of people. But what we see in the new rule that was published in August and that goes into effect on October 15th is a new definition of public charge that will really expand the definition of public charge to mean anyone who's more likely than not to use cash assistance or regular federal medical assistance or SNAP, otherwise known as food stamps, or housing subsidies, public housing. There are a couple of really important exceptions to the federal medical assistance programs that are implicated in the new public charge rule. Emergency medical assistance is excluded. Medical assistance for pregnant women and for children is excluded. And state-funded medical assistance also is excluded. So people who are eligible for medical assistance in any of those exempt medical assistance programs can continue to receive them without any public charge risk. Next slide, please. So just to give you all, for any folks out there who aren't doing public benefits work every day, just a kind of really brief overview of what these benefits programs are. Our cash assistance programs are TANF, general assistance, and SSI. TANF and general assistance are cash assistance for people who are living really in the deepest poverty that there is in the state of Pennsylvania. People on cash, on TANF or GA, generally have income at or around 20% of the federal poverty line. SSI is cash assistance for people with disabilities or people who are over age 65. And the SSI grant usually puts people at about 75% of the federal poverty line. And those two programs, remember, have always been implicated by under current public charge policy. The new benefits that are being added with the new rule include federal medical assistance. Federal medical assistance has income limits. For most people, it's up to 138% of the federal poverty line, but it can go as high as 250% of the federal poverty line. So a much kind of larger income level group that are potentially at risk by adding federal medical assistance to the list of benefits that are implicated in the public charge rule. Like I said, there are really important exclusions to the medical assistance programs that are included in this new public charge rule. Medical assistance for pregnant women, and that's through 60 days postpartum. Kids, that's up to age 21. Medical assistance for those groups are excluded, and that's really important because kids and pregnant women, there's a really broad range of lawfully present immigration statuses that can make people potentially eligible, make pregnant women and children potentially eligible for medical assistance with incomes all the way up to 220% of the federal poverty line. So a pretty significant group of people there who can continue to receive medical assistance if they're eligible without public charge risk. Similarly, emergency medical assistance, this is for people whose immigration status makes them ineligible for regular federal medical assistance and who have emergency medical conditions. Also a really important group to keep in mind because these are people with really serious health concerns who need to access health care and should feel safe continuing to access that health care if they're eligible for it. It will not put them at public charge risk under the new rule. Similarly, state-funded medical assistance. We do have a small state-funded medical assistance program here in Pennsylvania. It's also available to lawfully present people, which is a really broad range of immigration statuses. So these are very low-income people who usually are either disabled or elderly or parents. So folks who are eligible in one of those categories can continue to receive medical assistance in those categories without public charge risk. Food stamps, really brief overview, generally available to families up to 160% of the federal poverty line. For some people, it's up to 200% of the federal poverty line. And then the housing programs that are implicated in the new rule include Section 8 and project-based housing. The kind of good news, bad news here with the housing programs is that many programs in Philly have been closed for years. So there aren't many people who have access to those housing programs to begin with. So it likely, the addition of this to this in this public charge rule probably will not affect many people in terms of their housing subsidies. Next slide. So the public charge rule says that an immigrant's past use of one of the benefits programs that we just talked about for 12 months in the aggregate over any 36-month period after October 15th can be heavily and negatively weighed against them during a public charge determination. But it's really, 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 really important for everyone to keep in mind that there's pretty much almost no one who is both eligible for the public benefits named in the public charge rule and who are actually subject to the public charge grounds of inadmissibility. Next slide. So this is a chart that I hope helps to explain that. So all of these folks, all of these groups of immigrants listed on the left side of this chart have some access to some public benefits, but all of the statuses listed in green are exempt from public charge, right? So all of those folks, refugees, asylees, Cuban entrants, T visa holders, VAWA petitioners, green card holders, U visa holders, all of these folks can and should continue to access the public benefits that they're eligible for without public charge fears because they are exempt from public charge. There's that one little caveat for people with green cards who, you know, if they're traveling, they should keep their travel to less than 180 days abroad. But besides that, as long as they're coming and going in less than 6 months, even green card holders similarly should be safe here. The only people that we're really concerned about are the folks who are still, you know, who are applying for the green card or the visa on a family petition. They are subject to this public charge test when they're applying for the green card or the visa. But also, if you take a look here, really the only benefit that they potentially have any access to anyways is TANF. And I didn't list general assistance here because some of you might know that we currently, technically right now, we don't have general assistance. The state legislature eliminated general assistance. We here at CLF are fighting really hard to bring that program back. We hope we'll have it back sometime soon. But right now we don't have general assistance, so I only listed TANF as the one cash assistance program that's actually currently available to people in Pennsylvania. So just to kind of drive home this point here, unless you're working with a family who's applying for a green card or a visa on a family petition and who is applying for TANF, you most likely are not working with a family who has a public charge problem or who should be taking themselves off of public benefits because of public charge concerns. Next slide. An immigrant's family members' receipt of benefits will not be considered under the new public charge test. The only person whose public benefits receipt will count at all is the immigrant who is applying for the green card or the visa. So there is no reason why anybody should be, for example, taking their U.S. citizen children off of Medicaid or food stamps or anything else, taking your kids off of Medicaid or food stamps will not change your public charge risk at all. So your family members' receipt of benefits is not considered at all under the new public charge rules. Next slide. No benefits besides the ones we've already talked about will be considered under the new public charge test. So an immigrant's past receipt of WIC or earned income tax credit or unemployment compensation or workers' compensation, school lunches, marketplace subsidies, CHIP, state-funded medical assistance, emergency medical assistance for pregnant women and children, and lots of other stuff will not be considered unless it's one of the public benefits we talked about on slide 10. It will not be considered under the new public charge test. Next slide, please. Finally, so totality of the circumstances is still the rule. The statute that is in place, that's been in place for decades now, has always said and continues to say that totality of circumstances is the rule. So it cannot, so everything about an immigrant's life really has to be considered during this public charge test, and it cannot be that somebody's past public benefits receipt alone automatically makes them a public charge. And I'll say that for many people, public benefits receipt might even help them to not be a public charge, right? Because when somebody is able to access healthcare or access nutritional food, they are often able to be a more healthy, productive member of their communities and get to work and school and all of that. So I'm going to let Mary take over there and talk a little bit more about what the totality of the circumstances rule is.
Great. And for the folks who put in new questions, again, I think those are questions that are going to be covered later in the presentation. If we get close to the end and you don't feel like we answered the question, just let me know and we will try to go back and cover it.
Okay. So while it remains to be seen exactly how USCIS is going to implement the new public charge test, it has set out standards for consideration of each of the following statutory factors. So under the statute, it says that immigration officers are supposed to look at the totality of the circumstances, and these are the different factors: age, health, family status, household income, assets, resources, and then education and skills. So under the new rule, there's going to be more a focus on these different factors, and like I mentioned before, much less of a focus on the affidavit of support. And I'm going to talk about each of the factors one by one. Next slide. So first is age. So they're going to look at whether or not the alien's age, or whether or not the immigrant's age makes them more likely than not to become a public charge at any time in the future. So for individuals under 18 or over 61, that's going to be considered a negative factor based on the belief that they may not be able to work at that time. So we get a lot of individuals who, may be petitioning for their older parents, and if they're over 61, that's going to be something they may need to overcome under this test. So the next factor is health, and medical conditions that require extensive treatment or may affect the individual's ability to work are going to also be considered a negative factor. USCIS is going to look at where immigrants are required to take a medical exam as part of their application. They're going to look at the results of that medical exam to determine whether or not someone has a medical condition that might be considered a negative factor. And applicants who have medical conditions are going to be expected to prove that they can afford private health insurance to be able to treat those medical conditions once they either come into the United States or get their visa or their green card. Next slide. The next factor is family status or household size, and for that, USCIS is going to be asking, does the household size make the applicant more likely to become a public charge? And that ties in with the next section, which is assets, resources, and financial status. And they're going to be looking at the household income of the intending immigrant and whether or not that income is over 125% of the federal poverty level. Individuals who have assets to maybe prove that despite having a lower income, they have assets to provide for themselves, would have to be able to show more than 3 or 5 times any shortfall in their household income. The way that they would be able to show that would be through bank accounts, credit history, credit scores, tax transcripts for the last 3 years. In addition, for folks who may have medical conditions, being able to demonstrate that they have sufficient assets to cover medical costs. Next slide. And then finally, the final factor is education and skills. And USCIS is going to be looking at individuals' employment history, whether or not if they were eligible to work, were they working, if individuals have a high school diploma or above, any type of occupational skills and certificates, English proficiency, so folks will be expected to provide proof of attending English courses and, you know, certifications of getting more proficient in English. There is an exemption for under the skills and employment if someone is the primary caretaker in a house.
Please call 300.
Sorry. If someone's a primary caretaker, they're exempted from having to show employment history. Next slide. So in addition to just the simple factors, USCIS or the new rule has identified what they call heavily weighted factors. So heavily weighted negative factors, meaning it's not just a factor, it's a heavily weighted negative factor. And again, as with all of this, it remains to be seen how this is going to be put into effect. But heavily weighted negative factors would be if someone has no job history or prospects whatsoever and they are eligible to work, if they're currently receiving public benefits, which is what we've been talking about, if they were approved for public benefits for 12 months within any 36-month period after the date that the new rule is implemented. And I believe Mary Pat went into this, but a receipt of more than one benefit counts. So if someone's receiving 2 benefits, that counts double. Another heavily weighted negative factor would be if someone has a serious medical condition and doesn't have insurance. So heavily weighted positive factors that someone could use to balance out the totality of the circumstances test would be if they have assets and support above 250% of the federal poverty level, if they are work authorized and they themselves have income above 250% of the federal poverty level, and also if they have private health insurance, and that doesn't include marketplace insurance. Next slide. So as I mentioned before, the affidavit of support is not going to be the primary factor anymore. And in addition, USCIS is going to look a little more closely at the affidavit of support to determine the likelihood of the sponsor to actually financially support the immigrant going forward. So they're going to look at the relationship of the applicant and the sponsor and any co-sponsors to determine the closeness of that relationship. Is it a family member? Is it a household member? Is it someone who's, you know, not related and and doesn't have as close of a relationship to the immigrant. They're also going to look at, like I said, joint residence, whether or not the applicant and the sponsor live together. That will be considered a more positive factor. And whether or not the sponsor has sponsored other immigrants. So whether or not the individual signing the affidavit of support has signed an affidavit of support for a number of other immigrants. That will be considered a negative factor. Next slide. So for someone who is, if after looking at the totality of the circumstances test, the USCIS officer determines that the immigrant is likely to become a public charge, applicants who are found inadmissible based on the public charge grounds can apply for a public charge bond. These are going to be highly discretionary, so whether or not the bonds are really going to be available for most folks remains to be seen. And for a lot of the clients we work with, they may be out of reach because the minimum bond is going to be $8,100. Also important to note, bonds are not going to be available at all if individuals have any of the heavily weighted negative factors that I mentioned. So if someone has the public benefits for that time period and has a serious medical condition and no insurance, they won't be even eligible for a public bond to overcome the inadmissibility grounds at all. Next slide. So we wanted to give a couple case examples to sort of show what this looks like in practice. So first we have Susanna. Susanna has been living in the U.S. with temporary protected status since 2010. In 2014, she met and married a U.S. citizen, with whom she has 2 U.S. citizen children. In 2015, her husband filed a petition and an affidavit of support for her immigrant visa and green card. She received her green card in 2016, and now she wants to start the application process to become a U.S. citizen. She and her husband work, and they earn about $3,000 a month, putting them at about 145% of the federal poverty level. Her husband and children receive SNAP benefits, which is food stamps. Her children receive medical assistance. She also receives WIC for herself and the 2 children, as well as child care subsidies. She and her husband receive marketplace subsidies. She received TANF when she was pregnant with her first child. Before we go on to the next slide, my main question for you is Susanna subject to the future public charge test? So I'll give you a second to think about it. And we can go on to the next slide. Oh, so I didn't realize it was, okay. So is she subject to the test? So no, there is no public charge test during the U.S. citizenship process. So you remember, Susanna got her green card, we said in 2016. So she's not subject to the new test because she already has her green card and she's thinking about applying for citizenship. So the next question is, might Susanna think that she and her family should stop using public benefits? Yes. And the reality is, I know we've been getting a lot of calls from folks, and I'm sure Mary Pat has been as well, and I imagine you guys have been getting questions too. There's a lot of confusion and fear that might lead folks to believe that her or her family's use of benefits could cause her to be denied citizenship, but that's not the case. So the final question is, what should she do? She should keep herself and her family on benefits. If they need those benefits, they should absolutely stay on them, and she should get medical assistance if she's pregnant, because she might be eligible for that as well. So the next case example is Sandra. Sandra has been living in the U.S. with temporary protected status since 2010. In 2014, she met and married a U.S. citizen with whom she had 2 U.S. citizen children. In August of 2019, after she heard news that TPS for her country might be eliminated, she and her husband started looking into the process of filing a family petition and an affidavit of support for Sandra's immigrant visa and green card. She and her husband work, and they each earn about $3,000 a month, putting them at about 145% of the federal poverty level. Sorry, not they each earn. Together they earn $3,000 a month. Her husband and children receive SNAP. Her children receive medical assistance. She also receives WIC for herself and the 2 children and child care subsidies. She and her husband receive marketplace subsidies, and she received TANF when she was pregnant with her first child. So the first question, is Sandra subject to the public charge test? What do you guys think? So yes, she is going to be subject to the public charge test when she applies for her green card. Whether or not she's subject to the new test or the old test is going to be dependent on her. So the next question is, what should Sandra do? And my recommendation would be that Sandra should talk to an immigration attorney, and she should try her best to file her green card application before October 15th, because October 15th is when we expect the new rule to come into play. It's going to make it a lot more complicated for folks to overcome that public charge test, and there may be some folks who would have been able to overcome it under the current rules, but aren't able to overcome it under the new rules. So I would definitely encourage Sandra and any other folks who may be eligible for family-based petitions to file those petitions before October 15th. The new rule says applications filed by October 15th, no matter when they're adjudicated, will use the old rule. So the next question, or the next points to make, are to also remember, even if she isn't able to file it by the 15th, remember that the new rule doesn't consider her family members' receipt of benefits. So there's no reason for her husband and kids to get off benefits, even if she doesn't get her petition in by the 15th. Also, the new rule doesn't consider marketplace subsidies, WIC, or child care subsidies, as Mary Pat mentioned. So there's no reason for anyone, including Sandra in this case, to drop those benefits. Also important to note, the new rule doesn't permit retroactive application, so her receipt of medical assistance before the October 15th date isn't going to be considered. And it also wouldn't be considered because medical assistance for pregnant women is exempted under the new rule. Also, remember that totality of circumstances is still the rule. Her past receipt of TANF doesn't automatically on its own make her a public charge. And if it was more than 36 months ago, it wouldn't even be considered under the totality of the circumstances standards and factors. She has significant factors that would be weighed positively during the public charge test, including her family's income and her working, the fact that she was working under TPS while authorized to work. So,
Great. So I'll pick up with case example number 3. Sarah came to the U.S. on a temporary visa in January 2014. She applied for asylum, and after 4 long years, her asylum application was finally approved in 2018. Now she would like to apply for a green card. She's been receiving SSI, SNAP or food stamps, and medical assistance since June of this year. So is Sarah subject to a future public charge test when she'll be applying for that green card? The answer is no. Asylees are exempt from the public charge grounds of inadmissibility, so there will be no public charge test for Sarah when she applies for her green card. And there's no public charge test for anyone during the U.S. citizenship application process. So if Sarah subsequently decides to apply for U.S. citizenship, she won't be subject to public charge then either. But might Sarah think that she should stop receiving public benefits? Unfortunately, the answer could be yes. There's lots of confusion and fear out there, and that might lead her to believe that she should take herself off of the public benefits she's receiving. What should she do? She should continue to receive those benefits that she needs and that she's eligible for. So that's Sarah. I think our last case example is Sylvia, who came to the U.S. on a tourist visa, just like Sarah. She came with her husband, Samuel. Their visas also expired in 2014. But unlike Sarah, they have not applied for and received asylum. They have overstayed their visas, and they are here. They now have 2 U.S. citizen children, and they live and work in the U.S. Their children receive food stamps, medical assistance, and child care subsidy. Are Sylvia and Samuel subject to a future public charge test? Well, the answer probably is no, right? And this is a really tough conversation to have with a lot of undocumented folks who are very hopeful that there is potentially some future path to a green card for them. There aren't any clear paths here for Sylvia and Samuel with the little bit we know about them. And under the current rules, there really aren't many paths for many undocumented people to a green card. So if there isn't a green card path, there isn't a public charge test in their future. What should they do? Well, they should keep their benefits on, even if they do become eligible for a visa or green card in the future, and will be subject to a public charge test as part of that visa or green card application process. There are no benefits that they or their children can currently get that will put them at any increased public charge risk, right? So the public charge rule does not consider family members' benefits, so their U.S. citizen children, there's no reason to pull their U.S. citizen kids off of the medical assistance, SNAP, or child care subsidy that they're receiving. And the proposed rule doesn't consider any of the benefits that are available to Sylvia and Samuel now as people without status. So, for example, emergency medical assistance is available to people without status with very serious health concerns, but emergency MA is exempted under the new public charge test. WIC is available to people regardless of status, to kids under age 5 and to pregnant women. regardless of status. So potentially, you know, if Sylvia has another baby, she could become eligible for WIC, or if their kids are under age 5, they could be eligible for WIC now. WIC is not counted under the public charge test, so they can continue to get that. Charity care, if either Sylvia or Samuel need that to cover hospital bills, they should get that because it's not considered under the public charge test. And then services like medical care at FQHCs, community health centers, city health centers, food at food pantries and food cupboards, none of these things are, all of these things are available to Sylvia and Samuel if they need them. And none of them are considered under the public charge test. So there's no reason for Sylvia or Samuel not to get any of those things if they become eligible for them. So those are our case examples. Hopefully that helps kind of put this all in a little bit of perspective for you, help you understand how these rules will play out in people's lives. I did want to mention public charge deportation because there have been media reports on this. So I know that some people have heard about it and are worried about it and are wondering about it. So unfortunately, public charge deportation is a thing that exists out in the world. But we have not, like with the public charge grounds of inadmissibility, we have not seen any proposed changes to public charge deportation policies out of the Trump administration. So the public charge deportation policies that we have now are the same public charge deportation policies we've had for many, many years. And we don't have any clear understanding that that these policies will change in the future. We know that there are threats that these policies will change in the future, but we don't know precisely how these policies might change, and we don't know if or when they will. And they can't change without a lengthy regulation-making process that has not started yet. So, with that being said, I wanted people to understand about what public charge deportation policies are currently in place, because they are extremely restrictive, and they're so restrictive that they have resulted in pretty much no one being deported on public charge grounds. The public charge deportation policies in place are much more restrictive than the current policies on public charge grounds of inadmissibility. So in order to be deportable on public charge grounds today, you have to have received cash assistance or long-term institutional care for reasons that existed before you got to the U.S. And you have to have received cash assistance or long-term care during the first 5 years after you entered the U.S. And you have to have a legal debt to the government agency that provided the cash assistance or the long-term care and received a demand for repayment from that government agency within 5 years of entering the U.S. And you have to have refused to repay the benefit, and the government agency has to have filed a lawsuit against you and won that lawsuit in court. So that's a lot of ends, a lot of conditions that have to be in place in order for somebody to be deportable on public charge grounds. Next slide, please. Because of all of those conditions, public charge deportation, like I said, is extremely rare. As I understand it from national immigration experts, really virtually no one has been deported on public charge grounds. There are a few good reasons for that, right? I mean, these are two of the biggest ones, I think. First of all, the reason that in order to be deportable on public charge grounds, the reason that you, for becoming a public charge, had to exist before you even got to the U.S., right? So if you come to the U.S. and then you get injured, or you come to the U.S. and then you get pregnant, or you come to the U.S. and some other hardship happens to you here in the U.S., and that is what causes you to need cash assistance or to be institutionalized at government expense, then that doesn't count, right? So the disability or the hardship, you had to bring that into the U.S. with you when you came. And that is rare, but it's also hard to prove, right? that something like that existed outside the U.S. before somebody even got here. The other big reason is that there are no government agencies in Pennsylvania or anywhere else, as far as I know, that are suing people to get them to repay the value of cash assistance that they've received or the value of long-term care medical assistance that they've received to get into a nursing home. So without those government agencies seeking repayment and suing people to get repayment, there cannot be a public charge deportation under current policy. So this is a lot of information, right? And a lot of it is really, really scary for folks. So just have a couple slides here with just some main takeaways. First off, if you or you're working with a family who's applying for family-based immigration, encourage those folks to do so, if at all possible, before October 15th, so that they can have those applications adjudicated under the current policies rather than the new rule that goes into effect on October 15th. Second point, almost everyone who is eligible to receive public benefits in Pennsylvania can receive those benefits without public charge risk. Really want to encourage people not to either take themselves or their family members off of public benefits, or just choose not to apply for public benefits out of public charge risk. Please connect folks with people who can kind of give some good advice about that before disenrolling in benefits. If you are at public charge risk, there's no reason for anyone in your family, including your children, to forgo public benefits. Next slide. For low-income green card holders or low-income lawful permanent residents, don't travel outside the U.S. for 6 months or more if you can help it. And if you are planning to do that, please talk with an immigration lawyer before you do that. On public charge deportation, it's really important for folks to understand that how extremely restrictive those rules are, and that they apply to almost no one, and that there have been no changes to those rules that have been officially proposed as of yet. If you are applying for a visa from overseas, or you're helping a family member immigrate from overseas, connect with an immigration lawyer. The Department of State, as Mary mentioned at the top of the presentation, the Department of State handles those public charge tests that are happening in embassies in other countries, and the rules that are in place there are different and not as clear, and they're kind of in flux because they are making these changes to match the changes that USCIS is making here in the US. So talk with an immigration lawyer for help on that. And then finally, advocates are fighting really hard to prevent any of these changes from taking effect. So stay tuned for updates on there's litigation challenging USCIS's rule that was published in August, and there's also litigation challenging the Department of State's changes, the changes that the Department of State has made in consular processing overseas. So all of these things are being challenged. If there is a proposal to change the public charge deportation rules, I'm confident that there would be litigation to challenge that as well if we get to that point. There's still a lot to be done, right? So there's lots of community outreach and education, lots of folks that still need to be reached on this topic. So if you are working in an organization, or you're connected with community-based organizations who could use some community education outreach, some one-on-one sessions, please be in touch with me and or Sundrop. We can talk about arranging those sessions. We want to hear from folks about how public charge is affecting them. Sundrop created a form that people can use to report those stories. These stories are really, really important to our advocacy efforts, so please use that. The Department of Justice, like I said, we have heard these rumors that the Department of Justice is considering changing public charge deportation policies. The Office of Management and Budget is currently reviewing the Department of Justice's, whatever the Department of Justice wants to do. We don't know, we haven't seen what the Department of Justice wants to do in terms of changing public charge deportation rules. But we know that the Office of Management and Budget is currently reviewing the Department of Justice's proposals. So request meetings now, the Office of Management and Budget has to, if you request a meeting, they have to give you a meeting. So it's a really great way to make your voice heard now, get your concerns on the record, and if for no other reason, it potentially delays this process, and the more we can delay yet another terrible public charge proposal, the better. So request those meetings if you can. I have done a meeting. I've done 2 of these meetings now with the Office of Management and Budget, one on the USCIS rule and one on the DOJ proposal. So if folks are interested and want to talk, I'm happy to talk with folks about what's involved in that process and what those meetings are like. And I think that's our last slide. Is that right? Or no, we have one more, just some tools and resources if folks are interested. I think, yeah, there you go. PIC, Sundrop has created a public charge webpage, so check that out for additional resources. The national campaign on public charge, the Protecting Immigrant Families campaign, which is co-chaired by the National Immigration Law Center and the Center on Law and Social Policy. They're doing lots of great work on this, so join that campaign so you can get updates there. NILC has especially good, I think, information on those changes in the Department of State's rules around public charge during consular processing. So check that out if you're working with folks who are helping family members come from overseas. And then, of course, the Protecting Immigrant Families campaign has lots of their own handouts and resources if you're looking for community-facing material. And that, I think, is the last slide. We can go to questions.
Yes. So there's a couple questions. So a few clarifications on, so if there is someone in the U.S. and they are sponsoring a family member who is outside of the U.S., the question is, will the family member who is in the U.S., if they are receiving public benefits, will that be considered in the public charge determination for the person who they are sponsoring who is coming to the United States?
So family members' receipt of public benefits should not affect the intending immigrants being able to pass the public charge test or not. So no.
Okay. And then one, which either Maripat or Mary can answer, or also I can share, is just for service providers, most of which are not lawyers, either immigration attorneys or public benefit attorneys. Should they be concerned that talking to people about public charge will be considered giving legal advice, and any tips on how to make sure that they are not unintentionally practicing law?
I mean, I think the main thing is to, if you're sharing general information, so sharing the type of information we shared today, I think would be fine. Mary Pat, you sounded like you were going to say something.
No, yes, and I don't know, Sundrop, if we've shared the handout. So the CLS has a handout that's just a 2-page handout that summarizes what we've talked about today. I think if folks wanted to share that handout or a handout like it, the Protecting Immigrant Families campaign also has a bunch of similar handouts with fancier graphics that some people might find easier to read and understand. So, you know, use whatever handout works for you and your community. But I think certainly sharing information like that is entirely safe. And then for people who have, you know, more kind of in-depth questions about public benefit access, I think it's completely absolutely legitimate to just refer those people to community legal services or to your local legal aid program if you're not in Philly.
And similarly, I would say, oh, sorry.
I was going to say for our trainings that we do, one really easy kind of rule is if you're telling someone that, yes, they definitely qualify for a specific immigration status or benefit, or they 100% don't qualify for a specific immigration status or benefit, you are probably crossing the line. But if you're just educating them or explaining things without telling them yes or no, that you will definitely get declined or you will definitely receive your green card, you're probably fine.
Yeah, and I was just going to add, if folks have specific questions about an individual, or if an individual has a question about their specific eligibility and whether or not the public charge test applies to them, they can also call HIAS. Yeah, we're happy to work with folks on that.
Yeah, so folks, please, if you have questions, we still have a couple of minutes. We had made ourselves available until 3:30, so if you have questions, please type them in. Just for follow-up, we are recording this webinar, and we will make a copy of this webinar and a PDF of this presentation. So if you didn't memorize every single slide, a PDF version of this presentation and a link to the recording will be put on the PIC website in the public charge toolkit, along with a copy of the CLS handout that Maripat referred to. So give us a day, but by the end of the week, a copy of this recording, a copy of a PDF version of this presentation, and the handouts will be uploaded onto the public charge toolkit on PIC's website. Did anyone else have specific questions that you wanted answered before we close out? Please feel free to type them into the chat box. And if, housing benefits. So the question is, for folks receiving housing benefits but not listed as the primary beneficiary, example, a parent with U.S. children, could they be negatively impacted?
So, family members' receipt of benefits, including housing benefits, is not counted against an immigrant who is subject to a public charge test. So, housing benefits, but also with food stamps, it's very common for parents who don't have an immigration status that makes them eligible for that benefit to be able to receive benefits for their children. So I know food stamps benefits better than housing benefits. So with food stamps, a parent will get a card with their name on it, but on that card is just the benefits, the food stamp benefits for their two children, right? Because the parent doesn't have an immigration status that makes them eligible for food stamps. It's just food stamps for the two eligible children. It works similarly with housing, right? If somebody's getting a housing subsidy for kids, but they're living in the house with their children, as they should, the kids are the only people who are the recipients of that housing subsidy, and so that family's receipt of housing subsidy can't be counted against the immigrants.
Last call for questions. Any other questions? All right. Well, thank you everyone for joining, and check the PIC website in a day or two so that you can get a copy of the recording, this presentation, and additional handouts. And thank you to Mary and Maripat for spending the time and explaining this very complicated rule to everybody.
Thank you, Sandra.
Bye-bye.
Thanks.